the first to know Nsem-Pii TV.
Lawyer Paul Admochere Atamas na tiefo. Nsem de ebi ACC na NDC tirimu Paul. Omota echiri the removal of Chief Justice. Etiefo ti na hwe moye yoduma we mbehwe say wi. Na eno na MPP Eko Vincent Asefua ose ontiase na ntiase china watabiri asem no de Supreme Court. Bang. So oboa muni hu kwan some man fair hearing and some establish prima facie case. Then a lawyer pour out much retenase no dwam chiri pepe and be school ne enye no nko ha no wie no hyase omo ta echiri etefo utidi na na macho justice atuguba and some oka see say what nsema atuguba kan we am krabeso enye ho nko ha Felix Kwachi ofosu chese boshe bia NDC for the share ona wo ye judges ewo omo party se anyembia omo nso eso omo wura the Supreme Court eno no ma shase execute omo plan na tifo na Supreme Court entrance ehwe e Vincent Asefo asem ni wia eno ani behu the way bisi akọ ye bo asem na to anase asem ebegina Nina, Yankee, Wednesday, a second, and no, and as Nina on Betans. Young Coningo, lawyer Paul Admochere, and not in some children, and Brassicia.
Time that there has been such a massive attempt to remove a lady Chief Justice. The first one was during Georgina Wood. Incidentally, the circumstances were similar. The NDC had just won election after a two-term MPP government. John Ajekum Kufuor, he had appointed Georgina Wood after Chief Justice Akwa. As soon as the NDC came into office, there was incessant pressure on Professor Mills, then, and his vice president, John Dramani Mahama, to remove the Chief Justice, to accept a petition to remove the Lord Chief Justice. So it's almost like a deja vu. History repeats itself. When Akufo-Addo and when the MPP won elections in 2001, when John Kufuor came in, there was no issue about removing Justice Aban. Justice Aban was working. He felt completely unwell. And then he had to step aside for Justice Redu back in the day. And then in 2017, when Akufo-Addo came in, Georgina Wood was still the Chief Justice, having been appointed by John Kufuor, having survived the onslaught upon her during the Mills era. Professor Mills had to make a definitive statement publicly that as a law professor, he's not about to do something unconstitutional and remove the Chief Justice. So that also didn't work. John Dramani Mahama was the vice president of the time. Now, since the NDC won the elections, the things that we've been hearing, and tonight later I'll be showing you what Justice Atuguba said, which is very interesting, but we'll come to that in a minute. President Mahama is also being under incessant pressure to remove the Chief Justice, Justice Torkonoo, having been appointed by Nana Addo Dankwa Akufo-Addo in 2023. Torkonoo's appointment as Chief Justice came as a relief and as refreshing to many, given that she was the Chief Justice appointed in recent times who has practiced as a judge in all the courts of superior courts of judicature, the High Court, the Court of Appeal, and the Supreme Court. She had gone through the mill. She's been a judge for 20 years. Immediately, she came in and she had led many of the reforms under Georgina Wood, under Sophia Akufu, her predecessor. She had led many of the reforms, particularly the IT reforms that is now making the courts look more modern, like America. So many corporate people were quite excited about the arrival of Justice Torkonoo, because in our minds, Supreme Court judges were always constitutional law people. Justice Aban, Justice Redu, Justice Akwa, Justice Akufo-Addo of the past, Justice Apalu, and all of these men, ENP SOA, these were constitutional lawyers. You know, in those days, that's really what it was. Justice Torkonoo comes in with a breadth of different things: constitutional law, and more importantly, the administrative capacity to run the judiciary. So many were quite excited about this. In fact, in the final analysis towards the choice of Justice Torkonoo, one of the Supreme Court judges, whose name I will not mention now, said that if Justice Torkonoo didn't get the job and the other person got it, he was going to resign as a Supreme Court judge. Somebody said that. It's on record. We'll talk about it later. Many people know. So then Justice Torkonoo got into the 2024 election issues, where cases were going to the Supreme Court left, right, and center. As it is with almost every election season, you find a lot of writs going to the Supreme Court. In Ghana, in America, it's always the same. So she sat on some of them, and the NDC were not happy with some of it. The MPP too were not happy with some of it. In fact, recently she dismissed a petition against my favorite friend Kisi Ajabe, the special prosecutor. Justice Torkonoo dismissed that petition, which was filed by Ken Crunchy. And some MPP people were very, very angry with her that this woman is NDC and some NDC people too were very angry with her that this woman, when the Babin did the vacancy, she ruled in a certain way. Some MPP people said, did you see her body language at the court when Jogate was talking, a whole former attorney general and former deputy speaker? Do you see how she spoke to Jogate? She should get away from there. So there were some MPP people who were angry with Justice Torkonoo, and there were some NDC people who were angry with her. Then the NDC won the election. It didn't come as a surprise that concerns were raised about Justice Torkonoo and NDC people saying that she must leave, she must go, she must leave. So finally, it looks like the Constitution has what the lawyers call a lacuna, a gap, a space, something that has not been catered for. Because we all looked at it and said that, but in the case of the Chief Justice, who makes the prima facie? Because the Chief Justice makes the prima facie in respect of other judges. In the case of the Chief Justice, who makes the prima facie? There was a whole lot of confusion. And that's the beauty of democracy. The law is a living organism. So the law was expanded. Now, one man called Ejechum went to the Supreme Court to say that no, I think that the Supreme Court should find a way of adding to Article 1466. In the case of the Chief Justice, there has to be a way in which a prima facie case should be established. So what did Ejechum say? What is prima facie? We've already told you. Prima facie is whether there's a case to answer or not. This is Justice Dateba, who is still happily with us. Okay, so he says here, in my view, the objective purpose and spirit of the 1992 Constitution requires that a Chief Justice be given the benefit of a prior determination as to whether there's a prima facie case established against him or her before the President may establish a committee to consider a petition for his or her removal. This is what Dateba said. He says, in my view, the objective purpose and spirit of the 1992 Constitution require that a Chief Justice, Gertrude Torkonoo, Kingsley Akwa, Sophia Ekufu, be given the benefit of a prior determination as to whether there is a prima facie case established against him before the President may establish a committee, because we found out that there's no space in 1466 where this prima facie will be determined. So this is still Dateba. He says there is, and so we are talking about how the prima facie case, what the Dateba and the Supreme Court say about how the prima facie case against the Chief Justice should be established. Who establishes it? Is it the President? Is it the Attorney General? Is it other justice of the Supreme Court? Is it the former Chief Justice? Is it the Chairman of the Council of State? Let's get to the law. He says the issue which arises then from the discussion above is who is to make the prima facie determination. From the analogy in Article 1463, it is clear that the framers of our Constitution wanted an independent determination of the issue of a prima facie case. That is why they provided in the sub-article that the issue was to be referred to the Chief Justice for determination. In cases relating to the Superior Court judges, other than the Chief Justice. Similarly, I, Dateba speaking, do not consider it reasonable to infer that they would want the President himself alone to make the prima facie determination in case of a petition for the removal of the Chief Justice. There is a parallel need for a process which ensures an independent determination of whether there is a prima facie case against the Chief Justice. I, Dateba speaking, consider that the reasonable implication to be made from the context of Article 1466 is that the Council of State should play a prominent role in the determination of whether there is a prima facie case against the Chief Justice. Accordingly, Dateba continues, I am inclined to grant the plaintiff a declaration that the consultation by the President with the Council of State in respect of the appointment of a committee to inquire into the petition for the removal of a Chief Justice shall first determine whether the said petition discloses a prima facie case before the committee is appointed. So, long and short, Justice Dateban in the Supreme Court said that if the petition is for the removal of the Chief Justice, as we have now, between the President with the Attorney General behind him, and I remember that during the trial, those of us who covered the trial, during the trial, the questions were asked of the lawyers by the Supreme Court who were there. Dateban was super. And he said that you see, this case happened when Kufuor was a lawyer. When Kufuor was president, he's a lawyer. So they said that, okay, so who determines the prima facie? Some say the president should determine it. And then Dateban said, but it's not every time we're going to have a president who is a lawyer. Incidentally, after Kufuor came Mills, who was a lawyer. After that came President Mahama, who was not a lawyer. And then came Nana Addo Dankwa Akufo-Addo, who was a lawyer. But we were still going to have presidents who are not lawyers. So that argument came up. And then Dateban said in the court that it is for this reason that the president of Ghana has an appointed lawyer under Article 88 to advise him on legal matters. Article 88 is the article that establishes the office of the Attorney General. So now, Dateban says here that the prima facie cannot be done by the president alone. It must be done by the president with the Attorney General behind him and the Council of State. So this is where we are. This is where we are. Now, this Article 88, if you want, let me just go through it for lack of time. There shall be an Attorney General of Ghana who shall be a minister and a principal legal advisor to the government. So the Attorney General is a principal legal advisor to the government. So the president, in making his prima facie decision, can call upon the Attorney General who will send him a document. That's a document which the president can present in consultation with the Council of State's Judicial Committee first, which is chaired by Sophia Kufu, which includes Adinyira. And she will tell them that this is the view that the Attorney General has advised me and I stand by it. And then they can look at it and discuss it. So the question here then is, when Felix Kwakye Fosu sent the letter, is there more to read from Dateban? Okay, no, I'm done with Dateban. When Felix Kwakye Fosu sent the letter saying that President Mahama has transferred the document to the Council of State without saying whether they will be making a prima facie decision and then proceed to set up, you see, because when the document is transferred from the president to the Chief Justice in respect of other judges, the communication from the government will say that the president has transferred. In fact, there's one right now. There's one petition right now which President Mahama has transferred to Chief Justice Torkonoo for her to make a prima facie decision. And that is how the communication will be, that the document has been transferred to the Chief Justice to make a prima facie decision. However, in the case of the Chief Justice, and with what we now know, and with the document that Ofosu Kwakye sent, he said the president is consulting the Council of State about 3 petitions that has come for the removal of the Chief Justice. There was nowhere in there where he said that the president is consulting the Council of State pursuant to Article 1466 to make a prima facie determination whether or not the petition will fly. That was not said. Now, if that is what they are doing, then they will of necessity need to hear from the person against whom the petition is being made. Now, let's now get to the courts, the writs before the courts. Why is Asifwa suing? What reliefs is Asifwa looking for? And then we can understand the processes and we get on with it. So they're going to put the writs now. Is that the writ I have here with me? No, not yet. Okay. No, don't worry. We're good. We're good. Forget about the announcement. We're good. Let's get to the Chief Justice one. I think people are following us. Okay. So now the people in court, Vincent Akwa-Asifwa, whose lawyer is the former learned Attorney General Godfrey Adame, has gone to court with this. He's asking the Supreme Court to do as follows. He's looking for a declaration that on a true and proper interpretation of Article 146, 1, 2, 3, 4, 5, 6, and 7, and Article 23, 57, and 3, and 296 of the Constitution, the President is mandated to notify the Chief Justice about a petition for the removal of the Chief Justice and obtain his or her comments and responses to the content of such petition before referring the petition to the Council of State or commencing the consultation process with the Council of State for the removal of the Chief Justice. Second declaration, a declaration that upon a proper interpretation of Article so and so and so and so and so and so, that the President to notify the Chief Justice and obtain his or her comments and responses to the petition for the removal of the Chief Justice before triggering a consultation process with the Council of State. And because they didn't do that, that constitutes a violation of Article 1466, as well as the constitutional protection of the security of tenure of the Lord Chief Justice, who is a justice of the Superior Court of Judicature, stipulated in Article 1461 of the 1992 Constitution. A third declaration being sought by the petitioner is that he's saying that the court should declare that a failure by President Mahama to notify the Chief Justice and obtain his or her comments and responses to a petition for the removal of the Chief Justice before triggering the consultation process with the Council of State amounts to an unjustified interference with the independence of the judiciary enshrined in Article 1271 and 2 of the 1992 Constitution. Oh, whoa, there's a fourth declaration. What are they asking for? The fourth declaration is that failure by the President to notify the Chief Justice and obtain her comments and responses before triggering the process constitutes a violation of the fundamental rights to a fair hearing contained in Article 23 and 296 and renders the consultation process for the removal of the Chief Justice initiated by the President null, void, and of no effect. So the petitioner is saying to the Supreme Court that give me a declaration that upon a true and proper interpretation of Article 1466, that the President did not consult the Chief Justice against whom the petition is being made before triggering the process with the Council of State is null and void. It's a violation of her rights. It's a violation of the Constitution. This is simply what they are saying, that before the government told us that the petitions have been forwarded to the Council of State and therefore the process has triggered, before then they should have sent it to Madam Chief Justice so that she will put out her comments and her comments can form part of making that determination. Failure to do so should render the process null and void. Now, in addition to this, the claimants also filed an injunction that based on this declarations that they are seeking and based on this matter of constitutional interpretation that has been raised by their writ, and which is invoking the original jurisdiction of the Supreme Court. The Supreme Court's original jurisdiction is to interpret the Constitution. The Supreme Court has appellate jurisdiction to hear appeals from the Court of Appeal. But this original jurisdiction is to give a constitutional interpretation and meaning of the Constitution or many other laws as far as Ghana is concerned. So I believe this is the application for interlocutory injunction. It says that there's it's here. Oh, sorry. Let me look at this. Okay. It says, please take note that this honorable court will be moved on the day appointed by the registrar at 9 o'clock in the 4. The day appointed is Wednesday, 2nd April 2025. Please take note, it says, that this honorable court, being the Supreme Court, will be moved on the day appointed by the registrar. Day is 2nd April 2025. At 9 o'clock in the forenoon or soon thereafter, as counsel for and on behalf of the plaintiff applicant may be heard on the application praying for the following orders: an order restraining the President and the Council of State from proceeding on the consultation process for the removal of the Chief Justice under Article 146 or in any manner until the hearing and final determination of the instant action. So on Wednesday, we are all going to the Supreme Court. Big matter. Hopefully they can let us cover it live on television as we've been doing these days. The Supreme Court is going to sit on Wednesday to hear the matter whether or not in triggering the process with the Council of State, the President and the government of President Mahama have violated portions of Article 1466 of the 1992 Constitution. If the panel on Wednesday come to the conclusion that yes, the injunction should be granted, that is a big story. If the panel on Wednesday comes to the conclusion that the injunction fails, that is an even bigger story. What will happen? Let's see what happens. But Justice Atuguba has an idea. Justice Atuguba, our good friend, has an idea. And this is what he said. I was completely flabbergasted when I saw it. This is coming from a former Supreme Court judge who could nearly have been Chief Justice. This is what he says. He says, when the executive needs a reform, the president is changed. When the legislative needed a reform, the speaker was changed. When the judiciary needs a reform, the Chief Justice needs to be changed. If Nanado could remove the electoral commissioner, the auditor general, and it was good, so should John Mahama be able to remove the Chief Justice. Did he really say that? I hope he didn't. You know, these days you see these things. I hope he didn't. Justice Atuguba said this. I mean, Atuguba is the one who was teaching us. How is he saying that? In some countries, judges are voted for. And everybody knows that. Any political science students knows that. In some countries, they vote for judges. In America, they vote for attorney generals. Attorney General of New York is elected. In some countries, the Chief Justice is elected. They go to ballot and vote. In some countries, it's not elected. In those countries that the Chief Justice is not elected, there's a reason, there's a philosophy behind it why those countries decide that we will not elect a Chief Justice. Because they don't want the Chief Justice to be subject of electoral vote and vote and those things we do in elections, up and downs, and they vote. So when Justice Atuguba here compares the executive that is elected, that when we don't want the executive, we vote them out, and compares it to the legislature that is elected, when we don't want the legislature, we vote them out, and then draws in the Supreme Court that is not elected for the sanctity and protection of our national constitution. We do not elect Supreme Court judges, we appoint them. And then they have security of tenure of office, except they have done something egregiously wrong through impeachment. You don't remove a Supreme Court judge. Justice Atuguba says that because president is elected, because legislature is elected, even though Supreme Court judges are not elected, we should subject them to the equation of election. I think that is very sad, totally embarrassing, completely shocking that a distinguished Supreme Court judge will make a statement like this. I mean, why? Is it just the NDC and NPP politics now is doing us like that? I mean, why? As such a distinguished Supreme Court judge. I have a lot of respect for that policeman. I gained a lot of respect. TV's on Channel 1, TV's Bernard Able's show, Felix Kwachiofosu said something about the judiciary. Listen to it and let's see whether we can establish a trend. Have a listen.
Again, the Chief Justice is not at the beck and call of the president. She's the head, I beg your pardon, of an independent institution.
No, I'm talking about the view towards her. I'm not talking about whether she can be removed.
We have our own views. I have my own views on it. And indeed, Bernard, I'm sure you followed me. I've also been very critical of the judiciary. I don't think that they were fair to the NDC. To be honest, and I don't think they've been fair to the NDC for 32 years.
So even whilst you were in power in the previous...
Yes, I mean, you recall the Rollins era. The government of the day lost just about every case that went to court. You recall the famous case about June 4th and 31st December, the GBC case, and not the one that J.H. Mensah took to court in terms of whether ministers should be vetted again once they've been appointed ministers previously or not. We lost all those cases. Under the MPP, I would say, I'm a member of the executive, I'm a member of the Parliament, and I have not hidden my dissatisfaction about the way that the judiciary has performed in this country. Look, they were manifestly unfair. Again, the Chief Justice is not at the beck and call of the president. She's the head, I beg your pardon, of an independent institution.
I say more. I don't know. Felix Kwachiofosu says that the Supreme Court decision in J.H. Mensah and Attorney General was wrong. I mean, this decision that has been celebrated everywhere has become a backbone of our constitution. The decision in 31st December, which has been celebrated across the world by socialists and Democrats, Republicans, everywhere, that decision showed that the Ghanaian democracy had been born. Felix Kwachiofosu says that those decisions were wrong and that they were against NDC. Is there a trend? Is there a trend? Is there something somebody wants to do to remove a Chief Justice, to show muscle? And they have support from former Supreme Court judges, and they are getting this support, and they are moving on. Just for information, on the Judicial Council, the president has seats on the Judicial Council. One of the people President Mahama nominated to go on the Judicial Council was Kofi Totobi Kwache. The Honorable Kofi Totobi Kwache is a security and intelligence man. He's one of the nominees of President Mahama for the Judicial Council. Think about it. Food for thought.